Good morning. May it please the court. My name is Deborah Cluck, and I represent Evan Wright. He's a peace officer with the Riverside Police Department, the appellants in this matter. I've requested 3 minutes. It'll be a long day. 3 minutes of rebuttal, and I'll be mindful of the time I see it here. I won't go over. I encourage and invite the court to interrupt me at any time to redirect me to an issue that you want me to specifically address, or I have a lingering question you want me to answer. With that being said, this case is about at the heart of it, it's about two issues: the uncontrovertible body-worn camera footage and the reaching action by Xavier Lopez for a gun. The body-worn camera...
Let me stop you here. I've watched that video many times. I've paused it. I've gone really slow. I've tried to look at that as closely as possible, which, by the way, the district court judge did the same. It's clear from my review of that video and his order. When Mr. Lopez has his hands up, after he followed the commands to put his hands up, 2 seconds, according to the district court judge, and my review of that, have gone by before the officer shoots him. So the question to you is, first, is that not a constitutional violation? And two, was it clearly established?
So I'll take them in the order that you presented them. The body-worn camera does not show 2 full seconds of this, which is the hands up with the fingers spread out. Officer Wright does not dispute that if you take a screenshot of a moment in that almost 6-second video from the beginning to the end of the encounter, you will see hands in this fashion. But what's important is that you cannot look at that video through the prism of a screenshot print. That's the type of isolation that Pringle, Cortez, and Arvizu has told us, the courts, that you cannot do. But to specifically answer your question, it is what it comes before that, immediately before it and immediately after. He doesn't stay this way with his hands here. You have to keep rolling tape and do it slide by slide by slide. What he does next is not raise his hand, and his hands are not at his head. His hands are here, facing the officer, but he doesn't stay facing the officer. What he does next is instructive. What he does is he turns his head and his body, and his hands drop in the direction of the gun. The gun is right here. He's either going to, you can look at that and say that he reached, or he is going to flee. And he did that 9 days earlier.
Let me stop you here. Mm-hmm. Maybe there's a dispute about that, right? That one view is that he was reaching. One view is that he was not reaching and he had his hands up. So the district court found that that's a question of fact that's in dispute, that therefore could deny a summary judgment based upon that. The second question, I think, is an interesting one, which is there a clearly established law? Can you address that?
Well, because I'll do the second one first.
Right, okay, thank you.
The district court had to and did identify 3 cases that stood for the proposition that the law was clearly established. Now, keep in mind, we have a dangerous felon, and the record's clear on those dangerous propensities that occurred just in the 9 days before. Xavier Lopez is facing a vulnerable mother and his child a few steps away in a house that he had just broken into and threatened her with a gun, and behind him is his getaway vehicle that he had evaded arrest and has been convicted for evading arrest 9 days earlier. And those 3 cases, though, let's just stick to your point. CV, George, and Hayes. Mm-hmm. CV granted qualified immunity, so it doesn't stand for the proposition that the law was clearly established. George and Hayes never reached the issue of qualified immunity. In George, it was not addressed at all, and in Hayes, it wasn't an issue because the Fourth Amendment, in particular, wasn't asserted in that case. In George, it wasn't addressed because the defense didn't bring it up, so the court determined it to be waived.
Well, let's go back to CV. Isn't it the case that in CV the court the facts were a little different in that the person was holding a shotgun in their hand at the time, and if I remember correctly, the court there was focusing on that particular issue. So I guess it's different, isn't it?
I'm sorry, I missed
It's
that.
different, isn't it?
CV is very different. First of all, it was a 911 call, and the officers didn't have a dangerous felon that they knew had committed violent offenses previously and put the public at risk. Also, there were two suspects in that. One was completely compliant, and the other one had an issue. It wasn't an actual shotgun, it was a BB gun, but it looked reasonably like a shotgun. And when he reached, and that was the issue, and it's the issue here, the reach, he reached at the end of the barrel where the trigger was at the ground, and he was just turning toward it. There was no body worn.
CV seems similar to me in one respect at least, and that is that we're talking about a very narrow frame of time in which officers were responding to a perceived threat. And in that case, we found that there were tribal questions, but that there was no clearly established law. And it also reminds me of Casella, the Supreme Court case that came down not too long ago with a woman holding a knife, where the Supreme Court found that there was no clearly established law in those few seconds, in those moments of the officer responding. And here we have a 5-second gap at most between or 5 or 6 seconds between when Officer Wright leaves the car to when the shooting occurs. So again, a very abbreviated time. Is there clearly established law in this context where it seems like Mr. Lopez may not be complying with officer orders to get his hands free until near the end of that episode, where whether it's 1 second or 2 seconds, is there clearly established law that would have let Officer Wright know that he could not use lethal force in that circumstance?
Judge Sanchez, there's not only not clearly established law in the Ninth Circuit, there's not clearly established law in the entire United States of America. The facts of this matter in a brief 5 seconds, and really the issues of 2 seconds, less than the time that the light turns from green to red, and people are allowed that reaction time, and we know it's about 1.5 seconds. So it's right in that 1.5 seconds from perceiving a threat to taking an action. And in this case, there was a potential change in events. It's not disputed, it's on the body-worn camera. And then the officer would have had to perceive it and make another change. That's going to be at a minimum of 3 seconds. We've got 1,000, 2, 1,000, and this officer is within arm's length. You can see the officer's hand in his body-worn camera with a dangerous felon. There's not a single case.
But Casella, in that case, that person was, I believe, if I remember correctly, was she holding a knife, I think? And she was holding a knife and she was not complying with the officer's commands on 2 occasions, in fact, was told to put the knife down, was not. And then there was another officer that was very, very close. Are those facts different than what we have here, in that here, this particular person, Mr. Lopez, had his hands up, correct?
He had his hands for a millisecond, I mean, a fraction of a second here before he goes on to his next event. But I do think that there's a material difference. I can give you 7 acts of noncompliance in that 5 seconds. And in the 1,000, 2, 1,000 time frame where this highly trained officer, he's a member of the SWAT team, was within arm's length of a man that does this and then turns.
Well, isn't it the case that when the officer arrived, he knew that Lopez was armed, right? With a semi-automatic.
Had a reasonable basis to believe it because he.
Well, he had a police report from the victim who said he's carrying a semi-automatic black handgun. And during the 7-second tape, and I kind of agree with you, you got to look at the totality of the circumstances, not a micro slice. But even in this 7-second, which is pretty short, he pulled some black object initially, or started to pull a black object out of his coat, had it in his hand. So his hands were kind of flying around in that 7-second. They do go up at the end. There's no dispute about that. But looking at that as a whole, I mean, why would that not be reasonable for an officer to fear You don't, in our circuit, you do not have to wait, as I understand it, for a suspect to actually point a firearm at you before you can apply force, even if it's potentially deadly force. Isn't that right?
Officer Wright would respectfully agree with you, Judge Donato. And the court recently in Richard Bernal v. City of Glendora, Judge Mendoza looked at the body-worn camera in the light depicted by the videotape and found that the alleged force by the officer was not excessive. That's a legal determination. And under Scott v. Harris, you can look at it frame by frame. You can't judge the officer's conduct in hindsight, and you can never look at it in isolation. Pringle said the panel cannot view each in isolation rather than as a factor in the totality of circumstances. Later, Cortez by the Supreme Court said it requires the courts to consider the whole picture. And then in Arvizu, the whole is often greater than the sum of the parts, especially when the parts are viewed in isolation. 1,000, 1,000. We barely have done anything in that time frame. This officer had to respond to a gun and what Graham had talked about as the very tense, uncertain, rapidly evolving conditions involving death or serious bodily harm to everybody. The officer that was facing him, the officers that were approaching, the community, and the only thing between Xavier Lopez and the getaway that he had just done 9 days earlier was other officers. I have the 3 minutes reserved. Unless you have further questions, I'll take them up on rebuttal.
No further questions. Thank you.
Thank you.